Hi students, welcome to the BYJU'S Hindu News Analysis for 7th of August 2018. So let's get started. So let's look into the first article. So the first article says 3-judge Supreme Court bench to hear Article 35A issue. So let's try and understand everything with respect to Article 35A. Why is it important with respect to the Indian polity? So first thing that we need to understand is what exactly is Article 35A. So Article 35A of the Indian Constitution is that article which empowers the Jammu and Kashmir state legislature to define who the permanent residents are. So the first point that we need to understand in this article is who are the permanent residents, and this permanent residents is what the whole idea or this Article 35A is all about. So let's try and understand what it is. So it says that the rights of permanent residents are actually given in the state constitution of Jammu and Kashmir. So it is according to the constitution of the Jammu and Kashmir. We all know for the fact that Jammu and Kashmir has its own constitution, and according to the state constitution of Jammu and Kashmir, the permanent residents are defined. So who are the permanent residents? So the first point says, as a person who was a state subject on May 14, 1954. So if you are a person belonging to that particular region of Jammu and Kashmir on May 14th 1954, then you are a permanent resident. Then apart from that, it says who had been a resident of the state for 10 years. So if any person has been resident of that particular state for 10 years, then he is entitled to become a permanent resident. At the same time, has lawfully acquired immovable property in the state with reference to this particular date, then such person is called as the permanent resident. And this has to be decided by the state legislature, and the state legislature can alter the definition of the permanent resident by passing a law with a 2/3 majority. So in case the state legislatures actually feel that they'll have to change this particular permanent residentship, the definition of the permanent residentship, then what they need to do is they simply have to pass a law according to the constitution of the Jammu and Kashmir by passing a law with a 2/3 majority. So the permanent residents are actually given a permanent resident certificate which forms the basis of their rights in their state. So any person who has to have a proof that he is a permanent resident, and for him the proof is that he would be provided a permanent resident certificate which can act as an acknowledgement in showing him that he is actually the permanent citizen. So it has also a provision to recognize a permanent resident people who had migrated to Pakistan and returned, though subject to certain conditions which will again be decided by the legislature according to the constitution of the Jammu and Kashmir. So next point that we will have to understand is why exactly does it become important. So what are the various rights and privileges that all these citizens of Jammu and Kashmir have? What are the extra privileges that they have? So the point that we will have to understand is these people have certain privileges and rights that other people in Jammu and Kashmir will not have. So only those people who have this particular permanent resident certificate issued by the authority under the Jammu and Kashmir constitution will have certain privileges. So what are these privileges? First privilege that we will have to understand is with respect to the employment. So all these people who have this permanent resident citizenship, they would be provided employment opportunities under the state government or the state public sector jobs. Other people will not be getting these jobs. Only those people who have this resident certificate will be getting the employment opportunities that it be done by the state public service commission, or let's say for example there are certain public sector banks, or for example the sector industrial units. All these units will have only recruitment of those people who have this particular certificate. So the first important privilege is they have the employment provision, and second important provision is with respect to the property. So what does it say? Only those people who have this certificate will be able to buy the property. Anyone else apart from those residents will not be able to buy the property. Any person from Maharashtra, Karnataka, Uttar Pradesh or Delhi, whatsoever it is, these people will not be able to buy another property in Jammu and Kashmir simply because they do not have this particular certificate. And the third thing that we will have to understand is with respect to the settlement. So these people will not be able to settle apart from those people who have the certificate. So anyone else apart from those people having the certificate will not be able to settle in the Jammu and Kashmir region. At the same time, let's say for example the Jammu and Kashmir releases certain scholarships, or for example certain subsidies, and all these things will be provided only for the permanent residents. So all that it says is that right of the scholarship and other forms of aid that the state government is providing to all the people will be subjected to those people who have this particular certificate. So these are again with respect to the suitable legislations, and these legislations can be changed by the legislature according to the Constitution of Jammu and Kashmir. So these are some of the rights and the privileges that have been brought up. So what exactly is the controversy all about? So one of the major controversies that we will have to understand under this Article 35A is that Article 35A was actually incorporated by a presidential order by President Rajendra Prasad in 1954 on the advice of Nehru cabinet. So we know for the fact that any article, in case there is a new article that needs to be added, or in case there is a change in the structure of the constitution, this will require the permission from the parliament. So what we will require is a constitutional amendment, that is under Article 368. But what exactly has happened here is, without any constitutional amendment, there has been insertion of a particular article, that is through the presidential order, and that is only because the cabinet has actually accepted back then. How exactly did this happen? So we also know for the fact that there is one of the articles, and that is Article 370. So this is Article 370 which provides special status to Jammu and Kashmir. So according to one of the articles, that is Article 371 of Section D, it clearly says that there are certain provisions which actually allows the President of India to make certain exceptions as well as modifications to the Constitution for the benefit of state subjects of Jammu and Kashmir. So because of this particular exceptions and modifications that has been molded in Article 370, that is why President Rajendra Prasad actually accept this particular modification. So what the main question is, how is that a presidential assent was actually given without even changing the constitutional mandate? That is, in case there is a constitutional mandate, there is changing, repealing or addition of an article, it needs the parliament's consent. This cannot be taken by the cabinet or for example by the president. So this has to be on the basis of the Constitution of India, and that requires the 368 mandate, and this was not done. That is why it is ultra vires with the Constitution. Also another important point we need to understand with respect to the permanent residence is the provision mandates that no act of the state legislature coming under the ambit of the Article 35A can be challenged by violating the Indian Constitution or any other law of the land. So any person from Maharashtra would be able to buy a property in Karnataka, any person from Karnataka would be able to buy a property in Uttar Pradesh, Bihar and so on. But in this particular case, any person from Karnataka or Maharashtra will not be able to buy a property, and this is not a violation. Why? Because it is already laid in 35A, and that is why it is not a violation, is what it already says. So all these provisions are actually given with respect to a particular clause, and that is Article 370 that has been there in the Constitution of India. So what we will have to understand is, we will have to head back to the background. So what exactly is the main contention here? So there is one of the NGOs, and the NGO is named as the We the Citizens. They have actually challenged this particular validity of both Article 35A as well as Article 370. So what is the main problem right now, or what is the question in the Supreme Court is, how is that this 370 as well as 35A still retained? And what is the most important point is, the president has actually acted outside the jurisdiction of its powers. That's the first thing the Supreme Court has to answer. And how is that this particular act was actually given a presidential assent even before placing it before the parliament? So what we will have to understand is, there was already a Supreme Court case, and that was with reference to Puranlal Lakhanlal versus the President of India. So it was a judge bench that was constituted way back in the year 1961. So this actually discussed the presidential powers under Article 370 to modify the constitution. So what this clearly said is, there is Article 370. So Article 370 provides certain exceptions for the president to actually bring about a modification with respect to the state of Jammu and Kashmir. What it said was, yes, the president has certain powers to bring about a changes with respect to Article 370, and that is why he is added 35A. But what it has failed failed to answer is he capable of actually putting a new article? Yes, he can modify whatever is the existing one, but is he capable of adding a new article? Because 35A was not there, and because 35A was added by a presidential order, how is that he would be able to add, is what this particular Supreme Court case has actually said. So he would be able to make modifications, but in case there is an addition of a particular article, then it will require a constitutional mandate, which this particular Supreme Court case has failed to answer. So there has been a Supreme Court case in the past, and this is Puranlal Lakhanwal versus the President of India. So first thing that we also have to understand is, why is that this whole article, that is article 35A, required? So in case it is required, what is the important areas that we will have to look into? In case it is not required, what is the areas that we will have to look into, is what we will have to understand from this article. So one of the first things that we will have to understand is, let's try and discuss the arguments with respect to that article 35A should not be retained. So this article 35A should not be retained because it is not in line with the other states. That's the first point that we need to understand. So what exactly are the arguments for deletion of this particular article, that is 35A? So what it clearly says is, the first argument that we will have to understand is, it is a temporary clause. So first point that we says is that article 370 clearly says that it is a temporary provision which will actually help bring about normality to Jammu and Kashmir, to strengthen the democracy in the state. So we all know for the fact that Jammu and Kashmir actually to India with a particular accession treaty, that is the accession treaty that was signed by Raja Hari Singh. So what exactly happened was, this particular period there was a lot of trouble, and that is why article 370 was added, because they wanted to bring in a kind of stability in this particular region. It was a temporary provision, and now that Jammu and Kashmir region has actually been stabilized as a part of Indian constitution and polity, why is that this article has to be there? Because it was added as a temporary provision, now it should be removed, is the first argument that we need to understand. And the second argument that we need to understand is, this will actually violate the very principle of oneness in India. So what it is currently doing is, it is creating a class of citizens within India. So we all know for the fact that every person in India is same, whether he is a person in Karnataka, whether he is a person in Maharashtra, whether he is in Andhra Pradesh, Tamil Nadu, Kerala, all these people have the same kind of citizenship laws and all these things. But why is that Jammu and Kashmir has a different thing? So it is actually violating the spirit of oneness in India, is the second argument that we need to understand. And the third thing that we need to understand is that there has been certain violations of the fundamental rights. How is that it is actually violating? Let's take for example the article 14. So what exactly is happening is, we did discuss that only those people would be able to buy the property. What about other people? Say for example, any person from anywhere would be able to buy property anywhere in India, but at the same time these people are not able to buy the property in Jammu and Kashmir. So it is violating article 14, and at the same time it is violating article 21, because I'm not able to lead a dignified life, and for dignified life I need property, I need a house, I need a roof on my top. So all these things are not provided, so it is leading to violation of article 14, it is leading to violation of article 21. So this has to be looked into at the same time. So what also needs to be understood is, the right to vote is also violated. So right to vote is a constitutional mandate. So what exactly happens is, only those permanent residents, that is those people who have a permanent resident certificate, will be able to vote in the elections. But this is actually violating the constitutional principle of right to vote. Other people who do not have the certificate, who have been resident of that particular Jammu and Kashmir region for quite a long time, but they do not have the certificate, cannot vote in the elections. So this is a violation. So what exactly is the most important thing? The most important thing is with respect to the women rights. So what exactly happens? So we know for the fact that this has there is inheritance rights. Say for example, it go with respect to the land, there is inheritance from the grandfather to the father to the children. So what exactly happens in this particular case is, let's say for example, there is a woman who is a Kashmiri citizen, and then she happens to marry someone from Bihar or Uttar Pradesh. So in case she marries a man who is not a resident of Jammu and Kashmir, but who belongs to some other state, then the children of this woman will not get the inheritance rights, is what the point needs to be taken. So what exactly exactly happens? The progeny of this particular woman is not getting the inheritance rights. So this person's child is not getting the land, which is one of the important particle for economical stability. So what is happening is there is violation of the women's rights that is happening. So that is why Article 35A has to be suspended. And the most important point is that we will have to understand in this case is the discrimination. So what exactly happens? So all the political parties, we know for the fact, are having a certain vote bank, and because there is a particular section who are not entitled to vote in this particular case, they can segregate people, and because they are segregate people, they are actually making sure that there is discrimination between the permanent residents and all those people who have been staying in that particular region. So what will happen is the state government and, for example, the politicians can actually go on discriminating the citizens on an unfair basis by giving preferential treatment only to those people who are actually the president, who are actually the permanent resident certificate holders. So all these things actually say that 35A is actually ultra vires to the constitution, and that is why we need to remove it, is the argument. On the other side, we should also understand why 35A has to be retained. So the most important points is why this particular article 35A has to be retained is also needs to be looked into. One of the most important arguments is why it has been retained. Let's say, for example, the NRC that is happening. Why was NRC brought into picture? It is because certain people from Assam region actually felt that their cultural identity would be threat in case there is migration that is happening from some other regions. So the major point as to why 35A has to be retained is because when there are states which are actually saying that their cultural identity is important, why is that we the Kashmiri should let go it? So because it is our cultural identity, because it is something to do with our culture, we don't want people from outside to actually come and influence us, and that is why we want the cultural identity to remain intact, and that is why we want this retainship of 35A. So the most important thing is with respect to the cultural identity. So because we want to retain our cultural identity, that is why we want to make sure that Article 35A actually is sustained. So the point here is about the cultural identity. Now the next important point is with respect to what we will have to understand is, let's go back to Nagaland or, for example, certain regions of Mizoram. So there are certain provisions that are being given in the constitution. Let's take, for example, with reference to the Article 371A or with respect to Article 371G. So there are certain tribal heartlands where they are actually practicing their own types of culture, and at the same time land cannot be given to someone else. So there is already provision in some other states with respect to Nagaland, with respect to Mizoram, where land would not be given to other people. So when there are certain provisions which are already there with respect to Mizoram and Nagaland, why is that this is being removed for the people of Kashmir is the next point that we will have to understand. Because there are some historical reasons, and because there is a particular people who have actually allocated to that particular area, and because it is already given to certain other states, the same thing has to be retained to us. Why is 35A given to us? Because there has been certain historical reasons. So 35A should not be removed because it is already there in other states. There are certain special provisions that are provided, and that is why it has to be retained. And the third important point we need to understand is with respect to the historical background. What we need to understand is Maharaja Hari Singh actually came up with this particular provision, that is there were certain reservations. Why? Because there were certain elite people who were actually coming from Punjab region, who were actually taking up all the important jobs that were there with respect to the state government. So what exactly happened was, this particular provision was there even historically, basically to actually make sure that these people who are there economically at a very downward level are actually not dominated by the elite Punjab region. So in order to make sure that there is no economic deprivation, that is why this particular issue is actually there. So what exactly happens? Let's say, for example, this particular provision is actually removed. So there will be number of people who will be migrating from other states or other regions towards Kashmir right now. So because these people are actually migrating towards this region, those people who are economically downward within the region of Jammu and Kashmir will have problem. And because these people are already economically derived, they have certain reservations. Now because there are people who are coming from other regions, even these people start migrating and they'll have a lot of competition. And because there is lot of competition, what would happen in this particular case is the downward limit, the economical deprivation will further elevate. This is the third point that we need to understand. And also most important point that is always being said is that most of the industries are not able to buy the properties. So this is not the case, right? I mean, yes, there are certain things that only permanent residents will be able to take up a particular land, but what is also said is that this is actually factually wrong. So in case there is an establishment or an organization which wants to come up and set up a particular industry in Jammu and Kashmir, we are not saying no to it, simply because there is something called as 99 years lease. So in case you want to build up a particular organization or you want to build up a manufacturing entity in Jammu and Kashmir, take the land for lease and you would be able to bring about the infrastructural development. So it's not that we don't want development, it's not that we do not want to actually grow, but instead what we are instead saying is we would not give you a permanent land, but instead you can take land for 99 years and this can be further renewed. So what you would be further able to do is you can develop Jammu and Kashmir in the same hold, but that is because we already have certain provisions, and that is with respect to the 99 years lease. So please take up this particular license, please take up this particular agreement, enter into an agreement with the state government, bring up the industries that you want to, is another argument that we need to understand. And the most important point is with respect to the employment. So there are certain people in this particular area, and these people need the employment in terms of the state as well as whatever the state is provided. But in case there are some people who are actually migrating, these people will again have to compete with these people and the employment will be going under loss. And considering all these things, that is why we need to see the 35A has to be retained, is some of the arguments that we need to understand. So as of now, this is all we will have to understand. But moving ahead, let's keep a close watch with what exactly is happening with respect to the Supreme Court case, and whatever the observations are will be discussed in the near future. But as of now, this is all we will have to know with respect to Article 35A. So moving on, let's look into the next article. So the next article says the economics of tax havens. So what exactly is it article all about? So the article speaks about whether tax havens actually serve purposes or is it always anti-poor. So one of the things that we need to understand is tax havens are those countries which actually have low tax rate, or they do not have taxation which is at a very minute level. So let's say, for example, if with respect to corporate tax, the United States may charge at around 35%, India may currently charge at 25%. But what happens with respect to tax havens is they charge at a very less level, say for example 5% or 10%. So what exactly happens, all the corporations or the multinational corporations that are located in that home country will actually start sending all their profits to these tax havens because the tax rate is comparatively reduced. So what exactly happens is these rich corporations or the businessmen actually avoid paying high taxes on their income, and they actually start accumulating a lot of wealth. So even for that matter, organizations like Oxfam have actually characterized tax havens as the anti-poor. So kindly remember this statement. This statement can be used for any question that comes in terms of the tax haven. So let's understand some of the statistics first. So when you look into the statistics, what it says is, according to the recent paper, that is the missing profits of the nations by Ludwig Weir and others, about 40% of the profits earned by multinationals each year continue to be shifted to the tax havens. So what we will have to understand is, it has been told that tax havens are always a problem to a particular country because there are number of countries who are actually migrating from a home country to another country simply because they'll have to avoid the taxes. So because they are actually avoiding the taxes, the home country will not have taxes, so they'll not be able to spend on the social welfare schemes. So what is being said is that there are number of countries who are actually working out things in order to reduce this, so that all these companies who are there in the host countries pay taxes to the home country rather than shifting their bases to another country, that is the tax haven. So what we will have to understand is, this is one argument that which says the tax havens that are there, say for example the Puerto Rico and a number of countries, all these countries are a threat to the home country. Why? Because these people are having a very less tax rate, and because they have a tax rate, all these corporations are migrating their profits to these tax havens, and they're not paying the tax to the home country. And because they're not paying the tax to the home country, they're not able to execute a number of developmental programs. So there is a threat perception that is always there with respect to the tax haven. But what this article actually goes about speaking is that there is also a positive side as to why the tax haven has to be there. There is a provision that we know the tax haven is a threat to the economy. We are not going to discuss in detail about that provision, but what we will be discussing in with respect to this article is the tax haven has to be there. Why is that it has to be there is what this article all about. So let's try and understand what it says. So there was a particular paper that was actually published by the Juan Carlos Ruiz Sertato, which actually titled Unintended Consequences of Eliminating Tax Havens. So what exactly happened with respect to this report paper is he takes with reference to one of the sections, that is section 936 of the Internal Revenue Code of the United States of America. So what exactly happens is there is this particular section, that is section 936 of the Internal Revenue Code, which actually helped a number of American multinational companies to avoid paying taxes to the US government. So what it helped was, Puerto Rico is with one of the countries that we will be discussing here with respect to this article. So what exactly happened was Puerto Rico was one of the countries which was under the colonial imprint, and because this had a colonial past, this particular country was under the agrarian economy. So what US wanted to do was they wanted to make sure that this agrarian economy was actually transforming itself to a manufacturing economy. So what US felt was this is an economy which was always under the colonial past, and it was also an agrarian one, and they will also have to develop, that is Puerto Rico has to develop. So they did give certain exceptions under section 936. So what it said was that in case there is a particular manufacturing company or an organization or a multinational company, you can establish your particular organization in Puerto Rico, and you can set up manufacturing bases in Puerto Rico, and you don't have to pay the profits to the United States of America. So what it said was, in case you're already paying taxes to the Puerto Rico, you don't have to pay taxes to the United States of America. So this was a provision that was there with respect to 936. Why? This simply because the United States also wanted Puerto Rico to develop. But what exactly happened was, because United States of America actually said that you don't have to pay taxes to United States of America, number of countries started moving from United States of America to Puerto Rico. So what exactly happened was there was this existential threat to United States. Why? The simple reason is because the taxes were not coming. All the taxes that were actually supposed to come were not actually coming. But yes, there were certain major management companies which are actually located, but majority of the transactions was actually happening in the Puerto Rico. So because there was transactions that were happening in the Puerto Rico, tax were not being paid to United States. So what exactly happened was, with time, United States realized that all these countries are actually moving towards Puerto Rico, and this can be a threat to us because we are not getting the taxation. So with time, what exactly happened was section 936 that was there with respect to the United States and the Puerto Rico was actually removed. So because there was actually removal of this particular process, what exactly happened was there was a lot of problem, and those problems are what is being discussed in this particular section. So what it says is, Serento found that companies affected by the repeal of section 936 shifted their investment abroad. So what exactly happened was, so there was this management company which is already there in existence in United States. So the entire management team was sitting in United States, but the manufacturing was happening in Puerto Rico, but they were paying taxes with respect to the United States, but it was comparatively less. But what exactly happened, this section 936 was actually removed. So what exactly happened was the entire management itself started shifting to Puerto Rico or to some other countries. So there was a main management that was sitting in United States, but the minute section 936 was removed, the management itself started moving to some other countries. It can be Puerto Rico, it can be some other countries. So what it said was, though there was this particular tax havens, so tax havens was actually something which was detrimental to a country because tax was not being paid, but still what was happening was there was certain amount of taxes that was being paid to United States. Now with removal of this particular clause or this particular section or further restriction with respect to tax havens, what exactly happened was these companies started migrating all together to a new country, and because they started migrating, even the management started migrating to this country, what exactly happened was US saw a drop of about 38% with respect to investments, and this led to loss of about $1 million people's jobs. So what can be said is that there has to be tax havens, and this has to be rationalized. So completely restricting the company or completely alienating the company, what would happen in this particular cases, the companies would completely migrate, and this can be a threat further. So what we need to understand with respect to this particular cases, despite the crackdown of the tax havens, the practice of shifting profits to avoid paying higher taxes continues unabated. So what needs to be understood in this particular cases, in spite of having all this, there would be still tax havens would be giving this particular provision. You cannot completely restrict it. In case you go on completely restricting it, what would happen is there would be migration, and because there would be migration, we should avoid it. What this article further goes on to say is that all the profit shifting currently that is happening from the native country to the tax havens is having simply because the profit shifting persists, because tax authorities in high tax authorities, let's say for example United States of America, have been unable to eliminate the influence of tax havens that compete against them for their revenues, because there is less amount of tax rate that is there in the tax havens. That is why all the developed countries are not able to do it. So what you need to do is have a rationalized approach. Don't charge them too high or too less. Have a rationalist approach, and at the same time, in case you're not able to compete with these tax havens, what will happen is there'll be further inequality, because all these people who are currently there in the home region will be migrating to another region, and because they are migrating to another region, what they're doing is they're sending away the profits or the benefits to the stakeholders. So what will happen is the employment opportunity in the home region will actually go down, and the investments will go down, and because the employment and the investments go down, there'll be further inequality. How further inequality? Because all the stakeholders of this particular company are pushing away their profits or their benefits to the tax havens. So what you need to further do is rationalize this particular tax rate so that the company actually still stays back, the management stays back in the home country, but you cannot completely restrict the tax haven, is what this article actually speaking about. So moving on, let's look into the next article. So the next article says Supreme Court notifies norms for senior advocate status. So what exactly is the context? So context says the Supreme Court has now notified guidelines for according senior advocate designation to lawyers, and it has constituted a 5-member permanent committee which is actually headed by the Chief Justice. So what exactly is the structure? So when you look into the structure, what it actually says is there will be one of the permanent committees that will be established, and this permanent committee is called as the Committee for the Designation of Senior Advocates Committee, and it shall consist of a Chief Justice who will act as the chairperson, and then we will have the 2 senior most judges who will be the members of this particular committee, and then we will have the Attorney General of India, and then a member of the bar as nominated by the chairperson, and members as referred to by A and C. So you will have another member who will be taken from the bar. So this is the structure. So what will happen is this committee will actually meet twice in a year, and that will be in the month of January as well as in the month of July. So what we will have to understand in this particular case is, because of this particular process, there would be a particular secretariat, and that will be a permanent secretariat. So what exactly is the job role of this permanent secretariat? It will actually facilitate collating of details of all the probable cases. So let's try and understand how exactly it works. So who are those advocates who will be designated with the senior advocate status is the first question that needs to be answered. So this can be happening on a suo motu basis, or it can be happening on an application basis. First thing, let's discuss about the suo motu basis. So what exactly happens in the suo motu basis is, let's say for example the Chief Justice of India, or in this particular case the committee actually feels that there is a particular advocate who has a vast amount of experience and knowledge in actually serving law paradigm. So what exactly happens in this particular case is the Chief Justice of India as well as this committee actually nominates this particular person as the senior advocate. So it can happen on the suo motu basis, where this particular committee feels that there is a particular person who has a vast amount of knowledge with respect to law, and his experience in law needs to be deserved with some distinction, and that is why the Chief Justice or the judge may actually recommend the name of the judge in actually writing to the secretary secretariat to be considered for the designation of the senior advocate. And at the same time, there also needs to be another provision, and that is via the application provision. So in this particular case, apart from the CGI and the senior most judges and the committee naming it, all the advocates who are there can actually file an application. So the secretariat actually invites the applications from the retired chief justices, or for example the judges of the high courts, or those advocates who are actually seeking conferment of the distinction, and this happens every year in the months of January and July. So what exactly happens in this particular case is, an advocate on record who wants to seek this particular distinction as a senior advocate has to file an application, and this application will be scrutinized by the permanent secretariat that has been established, and all the details will be put up on the website of the Supreme Court. So with respect to eligibility, what is being said is, an advocate shall be eligible for designation of a senior advocate only if he has 10 years combined standing as an advocate or a district judge or a judicial member of any tribunal whose qualification for eligibility isn't less than the prescribed for a district judge, and at the same time it says retired chief justices or the judges of the high courts. So both these people would be eligible for actual designation of the senior advocate. So what we need to understand in this particular case is, how exactly is the procedure. So what exactly happens with respect to the procedure? So first thing is, all applications and written proposals are to be submitted to the secretariat. So let's say for example there is an advocate who wants this designation of senior advocate. So what he has to do is, he has to send in his application to the permanent secretariat. So this permanent secretariat will actually look into the entire application. It will see how exactly is the conduct of this particular advocate or the integrity, and they'll actually scrutinize the entire things of what exactly is the cycle of this particular cases. So they'll be looking into the past 5 years record. So once it is scrutinized by this permanent secretariat, it will be published on the Supreme Court website, which will actually invite suggestions and also views from all the stakeholders. When we say stakeholders, it can be advocates in the Supreme Court, or it can also be the government. So once it is put up on the particular Supreme Court website, what will happen is, it will ask for the viewpoint of the government. So they would be able to provide their viewpoint with respect to this particular application, and then what will happen is, whatever selected by this particular secretariat, that is the permanent secretariat, will then head towards the committee that is headed by the Chief Justice of India. So this committee, first it will be scrutinized by the permanent secretariat, then it will go to the committee. So this committee will further scrutinize it, and then what they'll have is the interview or an interaction with this particular person that is an advocate, and then they'll actually look into many dimensions. So what are the dimensions? One is the number of years of practice of the applicant from the date of enrollment. He'll get 10 points if he has experience of 10 to 20 years, and he'll get 20 points for practicing beyond 20 years. And then what are the judgments which indicate the legal formulations advanced by the advocate in course of proceedings of the course, what are the pro bono work done by the advocate, and domain expertise of the advocate in various branches of the law. This will take up 40 points. And what are the various publications, what are the articles that he has written, that will take up another 15 points. And test of personality, suitability on the basis of interview and interaction, that will again take 25 points. So after it has been scrutinized by the permanent secretariat, it will go to the committee that is headed by the Chief Justice, and then they'll scrutinize further, and then this will be finally sent to what is called as the full court. So what exactly happens then is, it will go to the Supreme Court full court. So these people will again scrutinize it, and they'll have their own set of interactions. If need be, they can also take up secret voting. Usually it will not be there, but in case they feel that there has to be a secret ballot voting, then that can also be enhanced. So what the full court will decide is whether this particular person has to be getting a senior advocate status or not. So in case the full court actually decides that this particular person has to be done, then personally there will be a particular communication channel that will be established, and then that particular advocate or that particular justice will be getting a senior advocate status. But what needs to be understood is, all this is for the advocates, that is this going to the committee for the designation of senior advocates under the chairmanship of Chief Justice. This happens only for the advocates, but in case they are, say for example, the retired chief justices or the judges of the high courts, it directly comes to the full court. It need not have to go to the provisions of the committee. So what we need to understand is, let's say for example, if it is rejected by the full court, in case it is rejected by the full court, what will happen is this particular person who has been rejected can apply after 2 years from the rejection. So if it is accepted, he'll directly become the designated senior advocate, but in case he is rejected, then he'll be able to come back to this particular forum once again after 2 years. Now let's say for example it has been rejected by the committee itself. So the committee itself, first it goes through this particular scale, right? So in case it has been rejected by a particular committee, then after 1 year he would be able to apply for this particular area. So this is all we will have to understand from this particular article. So the next is with respect to China tests hypersonic air activity. So this is important from your GS3 perspective, that is with respect to the defense. So what exactly are we speaking about? We are speaking about the Xingkong or the Star 2 Sky 2 important aircraft. So what we will have to understand is with respect to the factual data. So when you look into the context, what it says is China on Monday announced that it has successfully tested its first hypersonic aircraft which could carry nuclear warheads and penetrate any current generation anti-missile defense system, seen as a breakthrough in developing weapons. So what we will have to understand is China has actually developed one of the more important and the complicated systems, and that is the wave rider. So what exactly is it? It is a flight vehicles that flies in the atmosphere and uses shock waves generated by its own hypersonic flight with the air to glide at high speed. So it is flying at a very high speed and it will be able to take the nuclear warheads along with it. So the trajectory of this wave rider is relatively unpredictable in the glide, and it flies so fast that it poses an extreme challenge to current anti-missile defense system. So there are number of anti-missile defense system. These anti-missile defense system that are currently existing will not be able to actually recognize this particular warhead that is coming, simply because it is very fast and at the same time it has different trajectories that it has been taking. So this hypersonic aircraft was actually designed by CAA, that is the China Academy of Aerospace Aerodynamics, in collaboration with China Aerospace Science and Technology Corporation. So this flight vehicle actually reached 30 kilometers in altitude at Mach 5.5 to 6. So this defines about the speed. So this is all we will have to know with respect to this article. It is a very factual information, so kindly remember this factual information. So moving on, let's look into the awareness articles. So the awareness article says an IAS officer who quit to reform governance on your page 1. In case your optional is public administration, this can be used as the governance approach. So kindly remember the IAS name and see what exactly is happening with respect to this. Kindly make use of these articles for your mains preparation. And one of the other articles says Center molds way to block mobile apps. This is not clear cut. This will be discussed in the future because we still have no clear cut idea with respect to this article. 3 northeastern states emerge as new HIV hotspots, rebooting the skills for a skills upgrade. This will be discussed very shortly. Once again, it is an editorial, it will be discussed. And Rajya Sabha gives NOD for NCBC bill. This will also be discussed in detail. So both these articles will be discussed in detail in the future classes. So RBI must resume issuing LOUs and LOCs. This has already been discussed when we had the Nirav Modi scam. So you can look into the PNB scam, which is already uploaded by the BYJU'S with respect to this video. So 1/3 of PSBs remain headless. Kindly go through this article. Leaders must step up efforts to preserve India's global image, says former CA Kaushik Basu. So kindly remember this with respect to. So both these articles are very important. It can act as a fodder for your mains writing. So kindly visit the BYJU'S CNA, look into the practice questions, both pre as well as mains. Put in all your answers on the comment section. We will evaluate and give you the relevant feedback for the same. So this is it for today. Thank you so much. All the best.